LW Construction Corporation, versus Dupo, GR. Number 172342, July 13, 2009. Facts: Petitioner, a domestic corporation which recruits Filipino workers, hired respondent as Civil Structural Superintendent to work in Saudi Arabia for its principal, Mohammad Al-Mojil Group. On February 26, 1992, respondent signed his first overseas employment contract, renewable after 1 year. It was renewed 5 times. All were fixed-period contracts for 1 year. The 6th and last contract stated that respondent's employment starts upon reporting to work and ends when he leaves the work site. On May 28, 1999, respondent informed MMG, through the petitioner, that he needs to extend his vacation because his son was hospitalized. He also sought a promotion with salary adjustment. In reply, MMG informed respondent that his promotion is subject to management's review, that his services are still needed, that he was issued a plane ticket for his return flight to Saudi Arabia on May 31, 1999, and that his decision regarding his employment must be made within 7 days, otherwise, MMG will be compelled to cancel his slot. On July 6, 1999, respondent resigned. In his resignation letter, the respondent asked for his long service award in accordance with Saudi law. Petitioner did not respond. On December 11, 2000, respondent filed a complaint for payment of service award against petitioner before the National Labor Relations Commission, NLRC, Regional Arbitration Branch, Cordillera Administrative Region, Baguio City. Respondent averred that under the law of Saudi Arabia, an employee who rendered at least 5 years in a company within the jurisdiction of Saudi Arabia, is entitled to the so-called long service award, which is known to others as longevity pay of at least 1/2 month pay for every year of service. In excess of 5 years, an employee is entitled to 1 month pay for every year of service. In both cases inclusive of all benefits and allowances. Petitioning maintained that MMG pays its workers their service award or severance pay every conclusion of their labor contracts pursuant to Article 87 of the Saudi labor law. Under Article 87, payment of the award is at the end or termination of the labor contract concluded for a specific period. Based on the payroll, respondent was already paid his service award or severance pay for his latest, 6th, employment contract. Petitioner added that under Article 13 of the Saudi labor law, the action to enforce payment of the service award must be filed within 1 year from the termination of a labor contract for a specific period. Petitioner concluded that the 1-year prescriptive period had lapsed because respondent filed his complaint on December 11, 2000, or 1 year and 7 months after his 6th contract ended. Labor arbiter ordered petitioner to pay respondent longevity pay of $12,640 and 33 cents or 648,562.69 pesos and attorney's fees of 64,856.27 pesos. NLRC affirmed the decision of labor arbiter. CIA affirmed the decision of NLRC. Issue: whether the Court of Appeals erred in ruling that respondent is entitled to a service award or longevity pay of $12,640 and 33 cents under the provisions of the Saudi labor law. Held, yes, after a careful study of the case, we are constrained to reverse the Court of Appeals. We find that respondent's service award under Article 87 of the Saudi labor law has already been paid. Our computation will show that the severance pay received by respondent was his service award. Article 87 clearly grants a service award. It reads, where the term of a labor contract concluded for a specified period comes to an end or where the employer cancels a contract of unspecified period, the employer shall pay to the workman an award for the period of his service to be computed on the basis of half a month's pay for each of the first 5 years and 1 month's pay for each of the subsequent years. The last rate of pay shall be taken as basis for the computation of the award. For fractions of a year, the workman shall be entitled to an award which is proportionate to his service period during that year. Furthermore, The workman shall be entitled to the service award provided for at the beginning of this article in the following cases: A. If he is called to military service. B. If a workman resigns because of marriage or childbirth. C. If the workman is leaving the work as a result of a force majeure beyond his control. Considering that Article 87 expressly grants a service award, why is it correct to agree with respondent that service award is the same as longevity pay, and wrong to agree with petitioner that service award is the same as severance pay? And why would it be correct to say that service award is severance pay, and wrong to call service award as longevity pay? We found the answer in the pleadings and evidence presented. Respondent's position paper mentioned how his long service award or longevity pay is computed: half month's pay per year of service and 1 month's pay per year after 5 years of service. Article 87 has the same formula to compute the service award. The payroll submitted by petitioner shows that respondent received severance pay of Senior $2,786 for his 6th employment contract covering the period April 21, 1998 to April 29, 1999. The computation below shows that respondent's severance pay of Senior $2,786 was his service award under Article 87. Respondent's service award for the 6th contract is equivalent only to half month's pay plus the proportionate amount for the additional 9 days of service he rendered after 1 year. Respondent's employment contracts expressly stated that his employment ended upon his departure from work. Each year he departed from work and successively new contracts were executed before he reported for work anew. His service was not cumulative. Pertinently, in Branch School, Incorporated versus Zamora, we said that a fixed term is an essential and natural appurtenance of overseas employment contracts, as in this case. We also said in that case that under American law, here a contract specifies the period of its duration, it terminates on the expiration of such period. A contract of employment for a definite period terminates by its own terms at the end of such period. As it is, Article 72 of the Saudi labor law is also of similar import. It reads, "A labor contract concluded for a specified period shall terminate upon the expiry of its term. If both parties continue to enforce the contract, thereafter, it shall be considered renewed for an unspecified period." On the matter of prescription, however, we cannot agree with petitioner that respondent's action has prescribed under Article 13 of the Saudi labor law. What applies is Article 291 of our Labor Code, which reads, Article 291. Money claims. All money claims arising from employer-employee relations accruing during the effectivity of this code shall be filed within 3 years from the time the cause of action accrued, otherwise they shall be forever barred. In Catalan vs. Poe as administrator, we held that Article 291 covers all money claims from employer-employee relationship and is broader in scope than claims arising from a specific law. It is not limited to money claims recoverable under the Labor Code, but applies also to claims of overseas contract workers. The following ruling in Catalan vs. Poe's administrator is instructive. First to be determined is whether it is the Bahrain law on prescription of action based on the Amiri Decree No. 23 of 1976 or a Philippine law on prescription that shall be the governing law. As a general rule, a foreign procedural law will not be applied in the form. Procedural matters, such as service of process, jointer of actions, period and requisites for appeal, and so forth, are governed by the laws of the form. This is true even if the action is based upon a foreign substantive law. Restatement of the Conflict of Laws, Section 685 Salonga, Private International Law, 131, 1979. A law on prescription of actions is sui generis in conflict of laws in the sense that it may be viewed either as procedural or substantive, depending on the characterization given such a law. However, the characterization of a statute into a procedural or substantive law becomes irrelevant when the country of the forum has a borrowing statute. Said statute has the practical effect of treating the foreign statute of limitation as one of substance. Goodrich, Conflict of Laws, 152-153, 1938. A borrowing statute directs the state of the forum to apply the foreign statute of limitations to the pending claims based on a foreign law. Siegel, Conflicts, 183, 1975. While there are several kinds of borrowing statutes, one form provides that an action barred by the laws of the place where it accrued, will not be enforced in the forum even though the local statute has not run against it. Goodrich and Scholes, Conflict of Laws, 152-153, 1938. The courts of the forum will not enforce any foreign claim obnoxious to the forum's public policy. To enforce the one-year prescriptive period of the Almere Decree No. 23 of 1976 as regards the claims in question would contravene the public policy on the protection to labor,